Hey everyone, welcome if you just joined. I'll give everybody a minute or two to connect to audio and video, and then we'll go ahead and get started. Hey everyone, thanks for joining. I'm going to give it one more minute to let folks get connected to audio and video, and we will get started shortly. All right, thanks for joining today. It looks like we have quite a few people on the call, so I'm going to go ahead in the interest of time and get started. First of all, welcome. We thank you so much for joining us today. I'm Kendra Billa with AGC of California. And as you can tell from the flashing red light and the message when you joined, we are recording this session. So if you find this beneficial and you want to share this with your colleagues, please feel free to do so. Anyone that has registered for the event will receive a copy of the recording either later tonight or tomorrow when it's finished processing. I'll email that out to everybody who's registered, along with resources that we will mention today in the presentation. So look for an email from me either later on tonight or tomorrow with that information. With that being said, I just wanted to go over a couple of housekeeping items. In the interest of time, because we do anticipate that a lot of you will have questions, if you could submit questions to the panelists using the Q&A functionality in Zoom, that would really go a long way in helping us stay organized and making sure that we address all of the questions that come in. It really helps us on the back end monitor everything that's coming in and making sure that we can get things answered. So we appreciate your help with that. If you have any technical needs or need assistance with sound or anything like that, you can message me directly in chat. I'll be on the call the whole time, and so I can help with anything along those lines if you're having technical problems with Zoom. I would like to introduce Brian Mello. He is our Director of Safety and Regulatory Affairs here at AGC of California, and I'll hand it over to Brian to say a few words and kick off the session. Brian?
Yeah, thank you, Kendra, and thank you to everyone joining us today. I'm going to introduce our moderators this morning. We have Michelle Austin, who is the Director of Human Resources, myself, Brent Miller, Director of Risk Management, and Allie Wood, Marketing Manager. At this time, I'd also like to hand it over to the Director of Risk Management, Brent Miller. You're on mute, Brent.
You'd figure after 2 years we'd figure this out. So good morning, everybody, and thank you for joining us for a discussion about COVID-19 in the construction industry. As Brian mentioned, I'm the Director of Risk Management at Dome Construction, and like most of us on the call today, been learning an awful lot about COVID over the past couple of years. And one thing's for sure, every time we think things are settled, there's change, and we've got to continue navigating through that change. This webinar came together out of a conversation that we were having internally at Dome Construction with our board. And one of our advisors observed that we know an awful lot about COVID-19. Wouldn't that be great if we could share that more broadly with those out in the industry? We know from personal experience and that not everybody has had the opportunity to work with resources, and Dome has been very fortunate to work with some very terrific partners, all of which who are on the call today with us. And we wanted to help those folks connect to a broader audience. So when we reached out to those folks, instantly every one of them had said yes, they want to participate, they want to help. And with the help of AGC, we've been able to pull this together and reach out to the entire construction industry. And we're absolutely thrilled to have the panelists here today and want to share those folks with you. So I'll turn it over to Michelle and we'll get started with the panel conversation.
Excellent, thank you. I want to go ahead and introduce and say a huge thank you to our panelists, as Brent mentioned. So first and foremost, we've got Hannah Swice. Hannah is an employer defense partner with Phillips. And can go ahead and speak to us a little bit about the employment law side of COVID regulations and changes and that sort of thing. We've got Melgoza, a partner at Donnell, Melgoza Scates, who really has that expertise in kind of the OSHA side of things and can talk to us about enforcement, compliance, and things of that nature. And next we've got Jose Pianknagura, who is the Director of Construction with Arthur J. Gallagher, and can really talk to us about the impacts on productivity and cost associated with COVID. And with that, we will roll right into it. Our first presenters, Hannah and Manuel. Hannah and Manuel will really kind of start off here with kind of the impacts on COVID-19, what every employer needs to know, talking through things like OSHA, the ETS, and supplemental paid sick leave. So Hannah, Manuel, when it comes to COVID, there's obviously been a number of continual and constant changes with regards to requirements, and it's tough for employers to comply and keep up. So if you all wouldn't mind just kind of giving us a where are we now, where do things stand as of today?
Yeah, well, thank you, Michelle, and thank you, everyone, for having us here today. So you're right. I mean, things have continued to change, and I've even gotten questions like, "Is there even anything left for me to have to comply with COVID-19? Because the situation's much better. At least it is today, right?" I don't have a crystal ball, so I don't know what the future holds. But as of right now, I'm happy to report, as I'm sure many of you are, that at least the situation's better. But with that, in California, we do still have requirements that we do need to be thinking about and we need to be complying with. And that first one really is OSHA's emergency temporary standard that originally went into effect in November of 2020, and then now has been readopted 2 times. The most recent version of the OSHA ETS went into effect January 14th and is currently set to expire May 6th. But it can be readopted one more time. And OSHA is also working on a separate permanent standard. So this is really something to be thinking about currently, but also keeping an eye on for the future. Also, employers have to comply with certain requirements when it comes to quarantine, isolation, and keeping an eye on masking. And then, as Michelle mentioned, there are COVID-19 supplemental paid sick leave requirements that are in place. So in turning really to this first set of key requirements under OSHA's ETS, what do you need to think about? So as many of you know, the ETS applies to all employers and places of employment with very few exceptions. And those exceptions are those work locations where there's only one employee who has no contact with other people, and then employees who work from home or another remote location. And again, that would only exempt them while they're completely working remote. If they were to come to a location, then they would be subject to OSHA's ETS. And then the last group is those employees and employers covered by the aerosol transmittable diseases regulation, and there are other requirements under that. So now that we know kind of who this covers, which is generally most employers, what are those key requirements? So the first one is making sure you establish, implement, and maintain an effective written COVID-19 prevention program, provide training and instruction to employees on certain areas that are listed there. And then there are also notification requirements under OSHA's ETS when there's a COVID-19 case in the workplace. There are notification requirements also under the labor code. So this is an area of compliance, not only with OSHA's ETS, but also under the labor code. Employers also must provide exclusion pay to employees when they are excluded from the workplace because of a COVID-19 case in the workplace. And employers must comply with certain testing obligations when there's an outbreak in the workplace. And then there are also additional obligations when an employer provides housing or transportation to employees. So we'll get kind of more into the details of some of these requirements, but again, this is like from a high level standpoint, what you need to be thinking about with OSHA's ETS.
Awesome, thanks, Hannah. Manuel, can you kind of talk to us a little bit as it relates to the Cal OSHA ETS and what employers should know if Cal OSHA comes to conduct an investigation or an inspection?
From, our office does a lot of litigation at the level where after Cal OSHA cites an employer and then the employer appeals. So there's kind of two things that you need to look at in terms of where we are. One is that the appeals board has, the last count is over 500 appeals that that are called COVID related. And a lot of those appeals were based on citations that were issued before the emergency temporary standard. And there have been so many changes in the original standard and in the initial enforcement strategy that Cal OSHA used that those appeals are going to change. I mean, for example, a lot of the definitions changed. Some of them were taken out. Originally, Cal OSHA was enforcing using the 3203A requirement to have a safety program to identify these hazards, et cetera. Then they also said you have to follow the guidelines of the various health agencies. But then with the ETS, it's a regulation. So now the requirements have changed. So in those 500 and something appeals, a bunch of those are probably going to get weeded out because some of them no longer apply. The other thing that's happened on the litigation side is that I have not seen even one case, one appeal that's made it to the level of where the appeals board has issued a decision where employers would know, okay, how are they going to interpret this? And how are they going to interpret that? In fact, I haven't found any ALJ decisions that deal with the merits or demerits of a citation. But because of the backlog, you can expect that to be coming in. It's working its way through the process. Looking at it in the macro sense, I don't think that COVID is going to be it's going to take up as much of the focus as it is now because of a lot of things. First of all, COVID itself is not, it's kind of losing its significance in terms of the public's interest. And but the Cal OSHA's working on a permanent standard that won't just apply to COVID. So you can expect that that even though COVID itself may become less of a focus, the aerosol transmissible disease regulations are going to change drastically during the next 2 years. And so we're going to be looking at a different picture then, which means that for employers, especially for construction contractors, you know, two things are going to happen. One, complaints are going to still be filed with Cal OSHA because people will believe that everything that they've read applies. And so they're going to keep filing complaints, which generate inspections. And the division is not going to treat them any softer just because COVID is starting to fade away. So you're going to expect complaint investigation. And also accidents are going to continue to happen. So there are going to be requirements to report serious injuries, which construction employers need to know that the standard for reporting has been, the bar has been lowered. So there are more reportable situations. Those reportable situations you need to keep on top of because you'll be surprised. And I have a couple of cases like this where the employer thinks that they're not going to be affected much by the ETS because they work mostly outdoors. Their employees are not susceptible as much and all that. But that actually is a mistake to make that assumption because I have two clients. One of them was surprised to learn that one of its employees had died, and the employee, the hospital treated it as a COVID case. What does that mean? Well, Cal OSHA presumes that the that the death, if it's in COVID, uh, arose from the workplace. So you need to start gathering evidence anytime you learn that one of your employees, whether they're on leave or whether they're shifting to another job, whether what the cause is or the cause was. And so you need to start an investigation, and you have to be careful how you conduct it, because you don't want to create a confession for Kalosha then used against you. So we can get into the details later, but the construction contractors, especially if they work on HVAC equipment, where there's a chance that the HVAC equipment is connected with a healthcare facility or a hospital or something like that. If you're working on that kind of HVAC equipment, either upgrading it or installing it or whatever, there's a presumption that applies, and Kalosha will presume that that a COVID case was work-related in those situations. So you can't keep your guard down. You have to be on the lookout for any serious hospitalization really that has any connection with COVID. And to the extent that you can, you need to start trying to find out from the family members or co-workers or friends what they know. And we'll talk about how to be careful how you approach those investigations so that they will not be used against you while you're trying to comply with the law. So we shall see.
And following on that, maybe Hannah, we'll start with you kind of first. What does it mean to have a COVID-19 case in the workplace?
Yeah, so they basically under this regulation have different definitions for, different situations. So a COVID-19 case, and it's important to really think about the COVID-19 case in the workplace and your obligations. And when somebody calls you up and says, I think I'm feeling ill and they haven't been at work, is that a COVID-19 case in the workplace, right? So we have to look, one, is it even a COVID case, right? Because somebody that just calls us up and says, I have symptoms, we don't know, right, if that's a COVID case or not. And so the COVID case is actually now defined as either someone who has a positive test, a positive COVID-19 diagnosis, or is subject to a COVID-19 order to isolate, right? And all of those, again, have this tested positive or have a positive diagnosis. So that's going to be looking there first. And then the other is, someone who died due to COVID, which as Manuel just mentioned. And then you have to look at the work site, right? So is it where at the work site? Because work site's defined specifically again, and it's a building, store, facility, agricultural field, or other location where there's a COVID case that was present during their high risk exposure period, because that's going to be important, right? It's not just, I had COVID 2 weeks ago. It's, I was on your work site in that high risk exposure period when we're looking at the case itself. And then we have to look, was it just, one building and the person didn't go over to the other building? You have to think about that. So you want to look at the definitions very closely. And again, as I mentioned, this high risk exposure period. For those who are an actual COVID case, you have to look either with symptoms or without symptoms. And it's looking either if they have symptoms, it's looking back those 2 days before they first got their symptoms and then going forward until they isolate. So you want to see were they on your workplace at any time then. And then those who don't have symptoms but tested positive, you're going to want to look 2 days before they tested positive and then go forward to isolation. And that's really going to be how you decide who was a COVID case in the workplace. And I think, just kind of before we move into this next section, one of the points is that there's these key requirements, and some of them are documentation. And I think the point that Manuel made too, in terms of some employers say, oh, well, I work outdoors, right? But that's not one of the exceptions. So you should just, again, I think some of the low hanging fruit, most likely that Manuel sees when an inspector might show up to a site is they might say, let me see your written COVID-19 prevention program, and let me take a look at that. Does it have what's needed? And so those are things why, keeping an eye on these are important too. And then also the documentation of, training, instruction, and then we'll talk about investigations. So looking next, as you were going next, I think, Michelle, in this area, there's this COVID-19 case in the workplace, right? So now we have an employee who we've identified as being a COVID-19 case in the workplace. What now as the employer do I have to do? And this has changed because before we just looked to say, okay, do we have somebody who's fully vaccinated or somebody who's unvaccinated? Those are really the two groups. But now we need to look, okay, we have to look at the employee who tested positive, and then we need to look at anybody that this employee may have come into close contact with and figure out if those others that they came into close contact with, again, looking at our own employees, were either unvaccinated, fully vaccinated and boosted, and then, or were they some other status, right? So they were not yet booster eligible, they were booster eligible. So we're going to really need to look at their vaccination status to determine, can they stay on the workplace as a close contact, or do they need to be excluded?
And kind of piggybacking on that, Manuel, what would you say how would Cal OSHA prove that it was a workplace exposure to COVID-19?
Well, as I indicated before, you have to be careful about the type of work you do. The standard lists occupations where this applies, and you shouldn't assume that you don't have to comply with it, and that the burden of proof of the employer proving it was non-occupational. You need to look to see what type of work is involved, because there are some requirements that would bring you within the reach of that presumption. So here's my experience of what Cal OSHA, how Cal OSHA looks at enforcement, not of just this section, the 3205 or 5199. Because of pressure that Cal OSHA has been getting from the federal OSHA for the last, 15 years, because it was a complaint filed with the Fed OSHA that California was not issuing enough serious citations. And so Cal OSHA has been under pressure for those years by the feds to increase the number of serious citations. Well, they just got the goose that lays the golden eggs. They have this new regulation. And Cal OSHA now is required to enforce it. And so my experience is that an inspector will visit your work site and look for the things. First, they look at to see whether your programs comply. So they're always going to ask for records. They're going to ask for your safety programs. They're going to ask whether or not you've identified the hazard of COVID, of employee exposure to COVID. They're going to ask you for logs, injury and illness logs. They're going to ask you for your programs, like if you do have exposure, they're going to look at your COVID-19 prevention program, and they're also going to look at your respiratory protection program. And you need to have an assessment to determine whether or not you need a full program, or whether or not a abbreviated program will suffice, especially if you only require respirators to be used on a voluntary basis. So the inspectors will come and pick, as to borrow a term, I think Hannah mentioned, they'll look for the low-hanging fruit. So if you are overly zealous in the way you write reports and you make a determination that this is a COVID case, and you're very thorough, you may be signing a confession for Cal OSHA. And then we attorneys, when we get the case, we'll say, well, wait a minute, this was not even a COVID case. Why did you designate it as a COVID case? Well, I didn't know this, this, and that. Well, now I have to explain to the judge that even though you appeared to have admitted it, it wasn't really true because of all these other factors and information you found out later about the real cause and all that. So you have to be careful how you screen these and how you label these because the requirements differ. If you don't consider it a COVID case, then the requirements are less. If you do, then Cal OSHA has all these other procedures that they want you to fulfill. And if you didn't do them, that's a violation right there. So you have to be very careful in how you designate a case and make sure that the incident that you're looking into meets the qualifications of that, of whether or not it's a COVID case. So, you know, my experience is that the inspectors love it when the employers do an overly thorough investigation and provide lots of information that they can use to establish a violation. And the more you do, the more ammunition you give. So you have to be really careful what you put in writing. So, you know, that's my take on that. It's very hard to argue against a statement that was provided by a client that appears to say exactly what the division Cal OSHA says and how they interpret it. So yeah, you can avoid those things if you can do the things at the beginning, at the outset, that are going to you know, be accurate but not be overly generous in the information that you provide.
Right, yeah, and I was going to mention, Manuel, that I think, you know, with that, it's kind of looking at this COVID-19 case in the workplace. It doesn't mean that, you know, the COVID case itself was a work-related case. It just means that this COVID case was our employee that showed up to the workplace and had COVID. So I think that's an important distinction for employers to be thinking about as well, because regardless if that COVID case originated from our workplace or not, we do still have to look into the COVID case and take the appropriate steps, because either way, we could potentially put ourselves in, you know, an area for exposure, as you're talking about. So I think, you know, with the regulation itself, it says that you have to have an effective procedure to investigate these cases. It doesn't mean that you have to conclude that it was a work-related case in order to have that. So, you know, it's really walking this fine line of figuring out how do we do that, and then also, you know, not dig ourselves into a hole, as Manuel is saying, in terms of the documentation piece. So I think really taking a close look at the definitions and who meets those definitions, and then looking there to see, you know, what do we do next? So if you have an employee who is positive, again, regardless if the positive case originated from the workplace or not, but that person was on our work site, like I said, in the high risk exposure period, we're going to need to look to see where they're close contacts. Then there's another set of rules that apply. You know, do we exclude the person? Do we have them quarantine? What testing obligations do we need to meet? So I think in looking next, we can kind of take a first look at this area.
Excellent. And, you know, want to check in, maybe Manuel, this one's kind of more headed in your direction, but have employers really skipped over that regulations language that Cal OSHA has to prove an allegedly exposed employee's job had occupational exposure? And then kind of what does occupational exposure mean in plain language?
Right. Yeah, you know, I've seen that in some of the citations that our clients receive. Cal OSHA appears to just skip over the requirement that some of these measures that are required by 3205 or 5199 don't apply unless there's what they call occupational exposure. And even, you know, you would think that this term applies only to medical facilities, but it doesn't. Although healthcare facilities, there's a presumption that there's occupational exposure. The presumption is rebuttable. And if it occurs in a non-healthcare facility, the presumption still might apply because the COVID regulation states that it applies to employees with occupational exposure as defined by section 5199. So you have to look at 5199 to see if your construction activities make you vulnerable to that presumption. So, but I would always say, okay, wait a minute, you said this, the Kalosha alleges this, but you did not address whether or not that employee and the employee's job title and job descriptions show that they had occupational exposure. For example, I had one client who got cited for a serious violation, and it turned and they assumed that the employee had occupational exposure. And I said, well, wait a minute, did you look to see what that employee did? And how can you say that they had occupational exposure? The employee was a maintenance employee who had an office in the basement, had a different entry area, and all those things. So, that's one of the first things I look at, because if Kalosha believes that there was a occupational exposure to COVID, they're more likely to classify those violations as serious, and construction employers can't afford those to be competitive in the industry. So you need to really look to see at that point that Kalosha seems to have just bypassed and not looked into whether or not that employee's job was one that had occupational exposure, which also means that you need to be careful about what jobs you designate as having occupational exposure, because you may end up shooting yourself in the foot. And so, that's what I've seen.
And you've mentioned, occupational exposure. What are their definitions in sections 3205 and 5199? Need clarification for the employer's staff and who are enforcing those?
Well, clarification is hard to come by because the definition is not clear itself, but it does define occupational exposure at section 5199. Hannah, maybe you can put it in lay terms, but let's see. Occupational exposure, huge paragraph. It says exposure from work activity or working conditions that is reasonably anticipated to create an elevated risk of contracting any disease caused by ATPs, which are aerosol transmissible pathogens, something along those lines, if protective measures are not in place. In this context, elevated means higher than what is considered ordinary for employees having direct contact with the general public outside of the facilities, service categories, and operations listed in subsections A1 of the standard. Occupational exposure is presumed to exist to some extent in each of the facilities, services, and operations listed in subsection 1A1. That's the one I was referring to earlier, that just because you're a construction employer and your workers do mostly outside work, doesn't get you off the hook. You have to look at 5199 where it says what activities, if you engage in those activities, then the presumption applies, including, like I said, HVAC work in facilities that may be contaminated. Even if you just change filters, that might get you in trouble if there's if you're doing them in a place that might contain the contaminants. But what I would suggest here is you look at the job titles, because the paragraph does tell you that whether a particular employee has occupational exposure depends on the tasks, activities, and environment of the employee. And therefore, some employees may have no occupational exposure. So that's where you need to look and be careful. Make sure you look at any job descriptions that you have, because Kalosha will ask you for those job descriptions. 90% chance they'll do that. And if there's information in there that has been updated that no longer applies, but it shows that there may be some occupational exposure, they're going to presume that those employees do. So make sure you look at the job descriptions and that are accurate. And if they have any information that shows that they may have occupational exposure, then you need to reassess it and see if that's true, or whether or not the job description needs to be updated.
And just because I know this is like a lot of different information, just with regard to this issue of occupational exposure that you're raising, and then, the enforcement you're seeing, I think it might be helpful to just kind of further clarify that, Calos's ETS, as we mentioned earlier, really applies to most employers, right? And then there's this, ATD standard that you're talking about as well. And then we're talking about, if there's a COVID case, is it definitely a work-related case? Does it arise from the workplace? And I think what you're touching on here is, well, there's going to be different standards potentially about presumptions of where that case came from, depending on the occupational exposure. Am I understanding that correctly, Manuel?
Yes. In fact, the presumption, you will be able to see if the presumption applies just by doing your homework, by looking to see what the employee that was allegedly exposed, what their duties were, what their job description was, and any information that you have that shows that the employee was acting out of the scope of the job. And if he or she was, when they got sick or hurt, if they were working outside the scope of the job, then you need to be able to answer whether or not you did anything about it, whether you took steps to correct it. If you do your homework, you'll know whether or not the presumption applies. And if it does apply, you'll have the information to be able to rebut the presumption.
Yeah, and I think that's a helpful piece to understand, that as you're doing your investigation, you're really looking closely at, right, what the person's job was, what they were doing. When you're, thinking about what's the conclusion, a lot of these cases, of course, are inconclusive. We don't know. We can't generally say that they were work related almost all of the time. But because there's a presumption that stands out there, that's an additional thing to think about. So I think that's really helpful, to further understand.
So Hannah, Manuel, employers then should make sure they're taking steps that the two of you sort of outlined here in every COVID case, just to make sure that we've done our due diligence around these things, and can say we've not been able to determine a workplace source. Is that accurate? Or?
Yeah, I think it's going to be important to make sure you do investigate, like, in compliance with the regulation. And, there are very specific things that the regulation says you should document and you should look into, right? So what day and time the case was present at the workplace, and the date of the positive COVID-19 test or the diagnosis, there's some very specifics there. And then I think Manuel was also weaving in there, but be careful not to just give so much information or not really thinking through those specifics when you're documenting that process.
Yeah, that was a good point, Brett, because, if you're too hasty, because you have all this homework to do, don't draw any conclusions until you've gathered all the information and you've done all the homework. And don't be too anxious to say, yeah, this was work related, or this occurred at the workplace. Wait until you have all the information. Before that, the most that I would say you should do is say, this issue, whether or not this happened at work is under investigation. We don't know yet. So yeah, and I would actually go a step further, Brent. I would say that even before somebody thinks that you have a COVID case, I would say that anytime you have information that one of your employees has been hospitalized or has died, you need to start doing your homework there, because I've had a client that was surprised to receive a citation from Calosha 342A for failing to report, and the employer never knew that the employee had died from COVID. And this is very typical for a lot of our construction industry clients, because their workforce often moves a lot. I mean, sometimes they're piece rate workers. Sometimes they'll work 2 jobs in a month because, the jobs change. Sometimes things at the job that they're working in stop, and then they'll go somewhere else. And so there's these gaps. And so you don't always know where the employee was. You don't know that. I mean, it's not somebody who works, the full month straight or the whole season straight for you. And so you don't necessarily expect them to tell you that they're absent because, they're in the hospital. So I would say anytime you have any information that somebody has either one of your employees has either been hospitalized or has died, that you need to do some inquiry right from there. And then you have to use caution with the information that you receive. But
Yeah,
to be ready.
And I wanted to mention that I think too, like what you see a lot from your perspective is Cal OSHA coming in and saying, this was a COVID case. This was a work-related case, right? And I think what's confusing is there's obligations, regardless if it's a work-related case or not, you've got to follow these obligations and these requirements, regardless if it is. So I think, that's another thing to really think about when we're looking at this, because you have to act quickly, right? And we're going to talk kind of next about those requirements in further detail. But when you have to act quickly, you're not determining that it was a work-related case then, you're just following the requirements of notices and those kinds of things. So yeah, I think this is, one of those balances, thinking in the future about that potential issue that can arise, and then also thinking about what are my current immediate obligations.
By the way, one thing I would like to ask from both of you is trying to explain to our job site people and others what to document and how. There's a tendency in the construction job sites to basically come out to conclusions. Yeah, the guy was sick. And that is very important to be careful how you document it, how you write it down, because OSHA will get access to all those documents. And those are the documents that can hurt you when the inspector is reviewing. Then I think a little bit of conversation about that will be very important for our construction clients.
Yeah, and I think I would like to also hear Manuel's input, but for us, just from an, standpoint of making it a little bit easier as to what are at least the key pieces I need to collect to comply with the regulation. We have put together a contact tracing kind of sample that you can follow, where if I have a case, here are some of the questions I should be looking at and asking. And again, maybe thinking about not putting too much detail, but at least following and gathering the minimum information I'm going to need in order to comply with the regulation, and then also take the steps appropriate if I need to exclude somebody or do anything further. So from my standpoint, if, again, if that's something you're interested in, I have that as a resource, just a document, but that's one way in which we've, been dealing with that issue, so that at least to give you some guidance in terms of what to be asking.
Yeah, in addition to that, what I would say is that you need to kind of prioritize the level of diligence that you're going to use for cases that are arguably just above first aid versus cases where there's a death or there's definitely a serious injury with an extended period of the employee being unable to work, because two things are going to happen there. First, you need to make sure that your investigation is runs through someone, a central person that's involved in that investigation, so that everybody doesn't start collecting notes and interviews and everything else, and then you have all these statements that Cal OSHA is going to then use. You need to have perhaps one person coordinate and collect everything. Ideally, if the client can afford it, you should probably consult the attorney that you have and ask them whether or not they feel that a confidential investigation is warranted. Therefore, the attorney could say, okay, I want you to begin an attorney-client privileged investigation from now on. And then do not share any documents with anyone that's not involved in this investigation. And before you send anything out, let me look at it, etc. So you can have legal guidance as you do it. Most employers don't do that, but I tell you, after a while, and I do have some construction clients they have their safety manager or somebody always be in charge of the investigation and of writing the final report. And almost always they send a draft to me. And so we can look to see whether or not there's anything missing or that there's some red flag in there. So yeah, I would say that coordinate your investigation so that you don't make yourself a big target and so that you know exactly what's going on. And you just keep it as focused as possible.
Thank you. So now we've obviously, as an employer, we've now received notice that an employee has tested positive. We've worked through the investigation piece. When can these individuals return back to work?
Yeah, so I think, as I was kind of mentioning, we're going to need to look as we're doing that investigation, any close contacts and that employee themselves, and we look at vaccination status. So the one that, employee that actually has the COVID case, really, we don't have to look to their vaccination status at all, because regardless of their vaccination status, they are going to have to isolate for at least 5 days. And in California, they are going to need to test if they want to come back early. So they would need to test on day 5. And if they don't have symptoms and they get a negative test on day 5, they could return then. Otherwise, if you don't follow a testing regimen, then you would have them return on day 10, so long as they do not have symptoms. And, that's kind of what you would follow there. Now, with the close contacts, as I mentioned, you're just going to want to look at where does the person fall within these groups? Are they unvaccinated? Then that means, again, they're going to need to leave the workplace. If they're fully vaccinated and booster eligible, but they haven't gone and gotten their booster yet, then we're going to need to have them test on day 3 to 5, as opposed to day 5, for those who are boosted or fully vaccinated and not yet booster eligible. But those two groups, 3 and 4, do not actually have to be excluded from the workplace if they're a close contact. So that's where you can have them remain. You should have them tested. There's some, question out there about this language about testing, but, following that testing protocol on day 3 to 5. And then for the last one, and I think the group 4 just says it incorrectly. It says can't test on day 3 to 5, but anyways, test on day 5 in that last group. And then also about the masking. This is something that is also, another area where it's a little bit gray currently. Is the recommendation from CDPH is that you should mask, but there is also masking requirements still that reflect on Cal OSHA's website. So the safest thing to do is have people wear the face covering, well-fitted face covering for 10 days if they remain on the workplace. And so that's kind of really high level what you should be thinking about there with exclusion and isolation.
And Hannah, can you clarify who this applies to? Does this apply to individuals that have been exposed at home, at work, all of the above? Can you give a little clarity around who this applies to?
Yeah, that's a really good question, because again, this doesn't go to the work relatedness issue. If somebody is a COVID case, we're going to have to follow this regardless. If somebody's exposed outside of work, we're going to need to follow this. So that's a really good point. So this applies whether or not this was a COVID case in the workplace or outside of the workplace.
Yeah, just to follow up with that, there's a catch-22 in these regulations. For example, our clients have an injury and illness prevention program. They, for people who work outdoors, they have a heat illness prevention program, and now we have this COVID-19 standard. Okay, so the response procedures that you're required to put in a heat illness program may conflict with the procedures that you're required to follow for COVID. For example, a lot of the symptoms that are described in the regulation for COVID overlap the symptoms of a heat illness. And so the response procedures can create conflicts. Now, I've been arguing legally against that. I'm saying that it's not an appropriate standard for Cal OSHA to be using to say that that because an employee just has one of the listed symptoms, you have to treat it as a heat illness. Because, for example, I had a case where an employee exhibited symptoms that could be described either as COVID or heat illness. Well, my client, a construction contractor, got cited for a heat illness violation. But because the language allows employers to make that call about whether or not it's a severe heat illness, I argue that you need to let the supervisor on site make that decision, not second guess them by telling the inspector saying, oh, you should have called an ambulance. You should have stayed with the employee in the office, in the air conditioning, while you're calling the ambulance. But that kind of conflicts with what you do with an employee that you believe needs to be quarantined, that needs to be isolated. So you're going to expose the supervisor, the foreman, to be with the employee until the ambulance gets there. Well, aren't you exposing that person to COVID-19? So the first thing that you need to look at is to make sure that your programs don't add to that legal conflict. And you need to that's why you need to make a careful initial decision of how you're going to treat it. Are you going to treat it as a COVID-19 situation, or are you going to turn it into a heat illness situation? And if you're going to say heat illness and one of those symptoms that Cal OSHA considers severe is present, then you're going to have to call an ambulance. Instead of just saying, well, wait a minute, just because this person vomited, he says that it's because of the lunch he ate. Do I still have to call an ambulance? Cal OSHA says yes. So be careful when you're looking at your programs, when you're developing your response procedures, that your procedures are not contradictory.
And on that same note, Manuel, what would happen to an employer? Kind of what would those repercussions be if we were not to exclude folks in kind of accordance with the ETS?
Well, right now, I had a perfect case that would have decided that, but at the last minute, Cal OSHA decided to punt. So we never got a ruling on that. But we presented that to Cal OSHA and to the ALJ, but they never had to issue a decision. Our interpretation was that that you can't make that decision for the supervisor and then ding them later because he chose one over the other. You have to treat it like, okay, you give them that discretion, they follow the rules, as long as it's in substantial compliance, you can't cite that. If you want them to respond appropriately, you can't ding them later for the decision that they made. That's my interpretation.
But I think maybe to that point though, too, right? If they don't, if it's a COVID case and they didn't follow these procedures and they really didn't do anything, what do what advice do you have there in terms of the citation or enforcement?
I would say that once the supervisor or whoever it is, foreman, makes that evaluation after assessing the employee, that you make sure that whichever branch in whichever fork in the road that they follow, that they complied with it. Because the appeals board says, okay, so if you're going to say that the wrong regulation applies, the heat illness versus the COVID one, then you have to show that you complied with the one that you think applies. Otherwise, you can't use it. So whichever fork you use, make sure you follow it to the letter.
Excellent. This is great conversation. Thank you all. Obviously, in the interest of time, we're going to go ahead and put a pin in this conversation and move on to our next slide here. Allie, if you don't mind pushing us forward. Thank you. Awesome. Hannah, do you want to kind of talk through, things like notice requirements, things of that nature, and kind of who would be considered that employee in terms of those notice requirements?
Yeah. So I think, again, we can go through these pretty quickly, but we wanted to flag some of these key requirements that should just really remain on your radar. And like we said, the notice one originates, we have two places where we have notice requirements that we must comply with, both with Cal OSHA and then with the labor code. So we must, once we get notice of a COVID-19 case that was in the workplace, not just somebody calling us up saying, oh, I have COVID outside of work, meets that definition we talked about earlier, then we're going to need to provide within 1 business day, we're going to have to provide written notice to employees in the manner that we normally use to communicate employment-related information, and that communication should be received by that employee within 1 business day. And we should send it to employees in both English and whatever other language is understood by the majority of employees. And again, here's an area where, as Manuel said, do we have clarity on what that means? We absolutely don't. But, I think that if you know a lot of your employees speak another language, then you should be providing it also in that other language. And then we need to provide that written notice to our employees, but we also need to provide it to independent contractors who are at the work site at the same time as the COVID-19 case during that high risk exposure period. We also need to provide it to any union representative if that would be applicable. So those are in other areas where we need to provide notice. That notice needs to have very specific things in it. So it needs to have information about our disinfection and safety plan. It needs to have information about benefits if it's going to employees. And it needs to have information about testing if the employee or those who are getting the notice have testing that they should be offered. And then one other point is that the notice should not reveal the COVID-19 case's identity or any other confidential medical information. So that's another important point to think about, because I've seen over time now, people send me their sample notice and I'll say, Jane Doe tested positive, and was on our work site. And I'm like, no, you can't have the employee's name in there. So just another reminder there. And then in terms of the written COVID-19 prevention program, I do think we went through it. It is really important to look very closely at those key requirements. We can't do that in this discussion here today, but I think there's a lot of things to consider when you have that. And, it is one of those areas of low-hanging fruit, so it's important to have a good written COVID-19 prevention program. And then the training that must be provided, again, it has to meet certain criteria. It must have certain information in that training. And then employers shall maintain records of the written notifications for at least 3 years. So important to keep in mind as well that when you do those notices, you must keep record of those notices. And then again, keeping record of the investigations that you conduct and, all of that, as we've talked about as well. And then testing. When there has been even just one COVID-19 case in the workplace, you must offer testing at no cost during paid time to certain employees identified as close contacts, and then certain employees who have symptoms. If there are any testing obligations under the updated and exclusion and return to work criteria, you just have to really look at that, because you still have to comply with this paid time and all of that. It's a requirement of the employer. So as I mentioned, if you want to follow those shortened time frames, just complying with that. And then, this again is going to and from the test location. COVID-19 test is specific in terms of how you can test employees. And again, there's been back and forth because this most recent version really changed testing, but there has been some further clarification provided by Cal OSHA. This time around, Cal OSHA said a test cannot be both self-administered and self-read. And so, that caused a lot of confusion. What does that mean? And, I can use home tests, but then they can't be self-administered, self-read. So they came out with an FAQ, and I do think this one helps. And it says, how can an employer comply with testing requirements in the January 14th ETS? So to comply with the testing requirements of the over-counter tests may not be both self-administered and self-read, as I said, unless they're observed by the employer or an authorized telehealth proctor. This independent confirmation can be accomplished in multiple ways, and they give you more examples now. So they say, for example, the employer can validate the test through the use of a proctored test that is supervised, right, by a telehealth provider. or a point of care test provider. Alternatively, the employer could proctor the over-the-counter tests, including by video. So that's another option. An employee can make a video of the entire test from swab to result and then send that in, because that's another way they're saying that is acceptable. And then another way to meet the requirement of the test not being both self-administered and self-read is that there are some over-the-counter tests that feature digital reporting that you can use. So again, I think that has helped because that was a big area I was getting questions on. And so I think this FAQ has helped clarify that. And then I think one of the big areas to keep in mind as this OSHA ETS remains in effect is the exclusion pay requirement. And I'll touch on that just in a minute when we talk about supplemental paid sick leave. But employers must pay employees who are excluded from the workplace if they are, excluded because of a COVID-19 case in the workplace. So remember, going back to our scenario, if there was a COVID case and then an employee that was in close contact had to be excluded because they weren't fully vaccinated or they weren't vaccinated, then you would have to pay that employee that's out. The other big question is going back to, oh, well, what about that COVID case? And just because that COVID case, you didn't determine one way or the other, I don't know that if you go in front of the labor commissioner, you're going to win to say, well, I couldn't tell. I don't know if it was work related or not, because, I think as many of you have had these experiences, if you go to the labor commissioner, they're likely going to turn out and say, okay, well, what's in the favor of the employee? So in this area, we have been recommending to just err on the side of paying that exclusion pay. You do not have to determine that it was a work-related case in order to pay out that exclusion pay, but that will help you prevent and avoid a wage claim. And then again, there's some additional outbreak and reporting obligations from, Cal OSHA's ETS. And so some of those Manuel has touched on in terms of the reporting piece of it, or just thinking about, when there's a hospitalization or there's other situations. So I think maybe that's an area he can further flesh out, but keeping in mind that if there's outbreaks, you do have to report to the local health department, and there are additional measures you have to take.
Yeah, just to follow on that, this slide is really something that I would suggest people look at, because if I were an inspector in 2022, I would say, man, this is great. I can get a lot of other cases from this. So I'm going to ask if this construction company was it a multi-employer site? And so, I'm going to go look at these notices because I may get a lot of violations out of those. So one, it's going to generate more inquiries by the division. And so that means that your notices should be carefully, consider putting some disclaimers in there so that you don't admit that this was caused by you, but this company or whatever. So be careful how you word those and who you determine was there, because Cal OSHA will use those to either generate more inspections or citations. From a brief, the thing about training and the program development, from my brief review of what kinds of citations Cal OSHA is using, a lot of the violations that have been alleged are in the training area and in whether or not the employer properly identified, evaluated, and then taken measures to correct some condition. So the written program and the procedures that are actually implemented is going to be something important that you need to look at. Exclusion pay, that one out of every, I don't know, maybe 100 or 50 or whatever, that's going to generate a complaint to Cal OSHA. If somebody thinks that they deserve exclusion pay and didn't get it, there's a risk that they're going to go to Cal OSHA and file a complaint, which is going to, the investigator will determine whether it's going to be a partial investigation or if it's going to be a wall-to-wall. It's up to the inspector to tell you that during the opening conference. So so you need to look at that and carefully implement the provisions, because you can expect to generate some complaints to which Kalosha will respond. Outbreaks and reporting. Again, if I were an inspector, especially in 2022, where Kalosha now has the time because they've hired a bunch of new inspectors, bunch of new attorneys. Now they have time to go to every reported outbreak and conduct parallel inspections and really look to see whether or not there were violations. So yeah, these areas are very important areas where they implicate potential litigation. So yeah, I would just confirm what Hannah mentioned.
Excellent. And then Hannah, do you want to take just one quick moment and run through supplemental paid sick leave, and then we will turn over to Brent and Jose?
Yeah, and just right before we hit that, and I think we can go real quickly because there's not, I think the high level is easy to follow, and I think a lot of the details many people know, but I did want to point out that, yeah, these other obligations over there, like collecting vaccination status, even though it's not an express obligation in the regulation, it's going to be an area that's going to be looked at if you are properly excluding what's your process and things like that, in testing based on the statuses as we're talking about, it's going to be an important place. Cleaning and disinfection is a requirement, but again, it doesn't have a lot of specifics there. And then symptom screening is still around, again, not specific about what you have to do for symptom screening. So again, just keeping that in mind, and then masking, just keeping it on our radar, even though we've rolled back masking, it may come back. So, thinking about that, or when are these situations that we have to have masks? There are certain outbreak situations, or if there's, kind of, again, like I said, if you're exposed or in return to the workplace or stay at the workplace or have been isolated. And then I think, as Manuel touched on earlier, there's respirator programs to be thinking about complying with those as well if you have one. So those are some of the things there.
On the legal front, I think one of the things that is going to have to be resolved fairly quickly, at least within the next year, is that the masking requirement, because I think Kalosha is in kind of a untenable position because I remember having hearings in cases that involved the use of respirators where Kalosha was very meticulous about the type of respirator the employer selected and required to be used, and whether or not you had the right canisters and this and that. And they hated when the employers would just use a dust mask or give employees dust masks because they didn't protect against the contaminants that were in the workplace. And so N95s were treated as like, that's junk. You should select a good respirator. Well, now they come back and they're implying that these N95 respirators are effective against COVID infection. And I don't see how they could argue that. I mean, I just, the brief that I was working on, makes that argument that even a publication that was published jointly by the Gallagher Department of Public Health and by the Department of Industrial Relations says that N95s have a 10% leakage factor, and that is not appropriate protection against the valley fever spores, the virus. They're also microscopic. And so you're never going to be able to meet the effectiveness requirement that you chose an effective respiratory protection because N95s are not considered effective even by NIOSH's language and by the department. So I'm kind of presenting them with their own their own articles showing that these things are not effective. How can you say that we failed to provide them or failed to enforce their use during the entire work shift if you say that we still would have gotten a citation because these dust mask respirators are not effective because they don't achieve the desired result? So something's going to have to change. Either NIOSH is going to have to get into the business of approving a certain kind of respirator as protection for COVID, which in the case of valley fever, they declined to do, But in order for Calosha to implement a respirator requirement, they better tell you what you're supposed to use so that you don't get cited for a serious violation because the respirator that you chose was not effective. So anyway, that's one of the things we're looking for.
Yeah, it's been the whole thing over the masking and respirators.
I mean, the Department of Public Health also wrote a letter saying that they recommended that even for outdoors work, like in construction work where there's soil disturbing activities, that they do not think that the N95s are good enough. And so they were recommending that when you have that kind of work, that you actually use the PAPRs, the type of respirators that have a source of air that carry a hood and all that. But can you imagine a construction company doing a bunch of pre-construction work and earth moving and all that, and the employees are working, near excavators, and they have to wear these hoods with a tank with air? Not only do you subject them to heat illness, but they can get run over by one of the machines because they can't see them. So, but they acknowledge, the California Department of Public Health acknowledges that N95s may not be good enough, but yet their regulations seem to recommend them.
Yeah.
I think that's a problem.
Yeah, so I know. So really quick, just turning over to this California supplemental paid sick leave before we turn it over to the next section, is I just wanted to quickly highlight some of the main requirements. This law did go into effect February 19th, 2022. It does apply retroactive to January 1, 2022, and this is upon oral or written request by an employee. So you don't have to just go back and pay, but you should be on the lookout, oral or written requests. And then it currently expires September 30th. It applies to public and private employers with more than 25 employees. You must provide employees notices that are published by the DIR. There's a notice both in English and in Spanish that's publicly available. There's a pay stub requirement that you must comply with as of the effective date. So if you haven't already complied with that pay stub requirement, it's important to make sure you've done so, or you're going to be doing so going forward. Employees under this law, if they're full-time, they get up to 80 hours. And again, that's immediately upon oral or written request. If they're part-time, it may be less than that. Again, I'm not going to go into all the specifics as to how you calculate or what amounts, but it's going to depend on if they're, full-time or part-time employees, or if they work a varied shift. And then there's two buckets this time, which is unlike last year's, which means 40 of those hours are in bucket 1, and there's several qualifying reasons for bucket 1. And then bucket 2 is if there's a positive COVID test, either of the employee or their family member. And again, it's a specific definition of family member. And you can request proof of that positive COVID test before providing the supplemental paid sick leave. But another area here, just altogether, is be very careful about requesting documentation, because there's really only two areas. It's with the vaccine related leave under bucket 1, and then under bucket 2 here for the testing. And then, those are the high level of what you need to know for California supplemental paid sick leave. Again, as I mentioned earlier, if there's any resources, you're interested in, we have supplemental paid sick leave resources. We have the entire, grouping of CalOSHA's emergency temporary standard resources, in terms of documentation that you would need. So with that, I'm going to hand it back over. This has been a very enjoyable discussion for me here.
Thank you so much. So we're going to shift gears, and we're going to talk about COVID impacts in terms of pricing and price escalation and productivity. Jose, I know you've studied this quite a bit. You've written and published on the topic extensively. Starting with price escalation, what's happening right now? What can we do about it? I thought it might be beneficial for you to share some of the most recent impacts from that are coming out, like the Maxim Consulting Group has published some things. I know you have some particular stats that you wanted call attention to. So I'll turn it over to you for those.
Yes, good afternoon. Happy to be here. I want to try to be prompt, respecting everybody's time. Yes, there's some studies that come out, one of them by Maxim Consulting Group, talking about productivity in a number of areas. And I'm just going to provide one example that should tell a lot of what happened with the pandemic. The pandemic, the pandemic itself on a mechanical contractor affected them by 9.2% of loss of productivity. When you add all the related issues in order to comply with COVID restrictions and guidelines, so on and so forth, it becomes a loss of productivity of 17.9%. And that is throughout the different things that we do in a construction project. Imagine losing close to 20% of your productivity and what that does to your schedules. Then one of the things I would like to point out is when you're doing your schedules, try to do two different types of schedules: the schedule for the job and what is the right schedule without COVID related issues. In addition to that, then we go to the other side. What's happening with runaway costs? I was just reading an article published by the AGC on the 2022 construction inflation alert. And this is going to shock a lot of people. Steel and mill related products from 2020 to 2021 went up 127%. Plastic construction products, 34%. Aluminum mill shapes, 30%. Copper and brass, 23%. Gypsum, 21%. Lumber, 18%. And this was a study that was published a few months ago. Now with the impact of the war in Europe and the closures in China they have a zero tolerance for COVID-related issues, and they're closing whole cities. They're closing factories. What is that going to do with the pricing? What's that going to do with supply chain? When can you get the products, and how can you get the products? Go ahead, Brent. Let's move to other questions so we can try to be as comprehensive as possible.
Well, in this, before we jump off, I wanted to ask you, with everything that you've laid out as far as escalation wise, what should general contractors, trade partners, owners be doing to identify how long pricing can hold or be held for?
I think you need to have a very robust conversation before you get hired, once you get hired, before you sign the contract, and you need to create deadlines for change orders and pricing. I think pricing is in excess of 30 days in the current environment is too risky for contractors. You cannot afford to wait 45, 60, 90 days while you're negotiating, because those prices are going to change and you're not going to be able to sustain your pricing with an owner after 90 days. Then conversation, draft carefully your contracts, change order provisions, price increase provisions, escalation provisions. And then my favorite provision of them all is notice, notice, notice. When you negotiate your contract, make sure you understand what your notice provisions say. Make sure you understand how the notice provisions are drafted. Make sure to train your project staff. Usually contracts are negotiated at the executive level, but they need to be filtered down to the job site so everybody understands what you need to do, how you need to do it, who do you need to deliver notice, who do you need to tell this is happening, and also protect yourself on the other side. As a general contractor, your subcontractors are going to be sending you notice, and they're not going to hold their prices. I was dealing a couple of days ago on a project where 3 major contractors walked away because the owner was not able to finalize the pricing within 30 days. They basically said, I can go across the street. I don't have a contract with you. The costing and the pricing I gave you is over, and now you deal with the owner.
So your transparency, really calling attention to this and making it a very focal point of conversation is super important, is the takeaway here, right?
One of the things I've been recommending to some clients, if the job is big enough, it's worthwhile at this point in time putting somebody in there that's the chief of notices in the contract. You need to follow that contract. You need to be careful. And then over communicate. When you have your weekly, monthly meetings with the owner, let them know what's going on. And when you are negotiating the contract, make sure that your attorneys are very careful in limitations of liability, are very careful on how long a change order can be open. One of the things I like to do with my clients is tell them, we have a certain amount of change orders we're gonna allow to be open. Once you reach that point, we're not gonna continue to negotiate additional change orders because there's too much risk. Then again, be careful what you sign up for. No job is worth your company. And in this environment, you could lose your company if suddenly prices go 100, 150% higher than what you bid.
Ali, if we could push on to our next slide. So, with the supply chain issues, you mentioned China's zero COVID policy. They in the news this morning, I was just seeing Shanghai has more cases, so they may extend that lockdown. Where do you see this heading?
I think it's gonna get worse rather than better. One of the things I'm suggesting to my clients is pre-buy, negotiate with the owner so the owner provides the funds for you to buy your supplies way ahead of time. Make sure you put in enough time in your schedule in case you have some supply hiccups. There's gonna be delays from China. There's now gonna be delays coming from China to the United States because ships are gonna have to circumvent anything that's Russian related. They're not gonna be able to come directly here. And that's gonna create additional supply chains. And also remember, everybody's trying to get the products and try to get them ahead. It's like, when there's a little bit of a supply run in supermarkets, everybody wants to get as much as they can so they don't have to suffer the delays. Then try to plan, try to talk, try to make sure that you don't get stuck where suddenly you have 6 months, a year of delay, and you have to pay for liquidated damages. Make sure that your contracts, as I said before, contain proper liquidated damage, contain a waiver of consequential damages. That in this market is crucial because that can kill you. And also some limitations or liability. I've always told my clients, I used to work for Hunt Construction, AECOM Hunt. We never go to a job not to make money. Then our limitation was basically half our fee. Those are things that need to be thought about. Those are things that need to be negotiated. This is not the time to say we have a contract, we have a great client, we've never had a claim. You might have a claim because your subs force you into a claim, and then that claim needs to go upstairs. If you don't have the right language in your contract, that's gonna come out of your net worth. And no job, again, is worth your company. And we're at a time, and it'll get even worse, where we're gonna have to be facing those things. Train your schedulers carefully to understand what's going on with the supply chain, to understand what's going on with productivity. When you have a loss of productivity of 20% or higher because the experienced superintendents are retiring or choosing not to come to work because there's a lot of additional cost in gasoline and other stuff, understand how much you're gonna be able to do and how much you're gonna be able to produce, because at the end of the day, the general contractor is the one that's on the hook in most cases, unless you have a cost plus contract for the cost and the liability of that project not being completed in time. Whether or not you get the products, that's your responsibility, unless you've crafted language that's equitable, where you share that with the owner, you share that with others.
So again, you're really recommending those issues be called attention to, and that together, general contractors, trade partners, the client are discussing those as part of that upfront before the contract sign. You're working into the agreement limitations of responsibility, liability, and like trigger points for decision making and product release and that sort of thing.
Absolutely. You need to create proper timing for these things. If you provide the owner a price and the owner sends it to the architect or the owner's rep, you can't wait 6 months. You can't wait 5 months to negotiate that price. they need to agree on the price now, because that's the only way you can secure it from either your suppliers or your subcontractors. Waiting is going to cost you money, and then you're going to get into a fight. You know, I get a lot of clients that say, Jose, we've been doing 30 jobs for this owner and we've never had a problem. Well, the 30 jobs and the friendship with the owner ends when you have a problem that's going to cost you multiple millions of dollars. The owner might not be able to get it from their lender, and you might not be able to pass it on to anybody else. Then be careful. And once again, read and file notices. Make sure you are not biting too much. And one of the things I've always told my clients, there's jobs that are good enough to walk away. There's jobs that you just do not need, because you do not want to risk your company for one job, two jobs, whatever it is. Just say, no, thank you, it was fun. Or let's negotiate proper provisions so my liability makes sense for this project.
Well, unfortunately, I think that's about all we have time to dive into this afternoon, but I think we could go on for hours with this topic, and perhaps the AGC will have us back to expand on that conversation. So, Brian, I'm going to turn it back over to you. I wanted to say a tremendous thank you to Hannah, to Manuel, to Jose, to Brian, to Kendra and Michael at the AGC of California. Really appreciate you folks helping us pull this all together. And thank you to our audience. Brian, take it away.
Yeah, thank you, Brent. Thank you for everyone that joined us today. Manuel, Hannah, Jose, thank you so much. What we'll do for all of the participants, we will provide the content to everyone with the recording after this. What we'll also do is we'll provide contacts for your panelists here today. If you have any further questions, please feel free to reach out to them at any time. Reach out to myself. We're here to help. Things continue to change. We'll be on top of it. So if there are any questions, please feel free to reach out to our panelists or myself. And then again, a big thank you to our panelists and Dome Construction for putting this on today. We really appreciate your time. And with that, thank you everyone, and have a good rest of your day.
Thank you.
Bye.